The popular impression, myth, is that Europe has a lot to teach and Asia has a lot to learn. I concede the Europeans have been at some of the things that we are talking here a bit longer. They have a way of doing it in a more organized way, in setting up commissions, in setting up courts, in setting up conventions. And to that particular stimulus and energy that Asia would be looking up to finding a way forward. But this is not to say that Asia has not something to teach Europe. In the interventions that I've made in the seminar yesterday and this morning, I tried to show to the participants the unique leadership that the Asian judiciary has shown in human rights and sustainable development issues. The point that I tried to make was that the judges in Europe have been fantastic. They have been good judges, true judges, and well-trained judges who have looked at the law, who have looked at the treaties, who have looked at binding law to interpret and enforce. But where the Asians have a vision to hold out to Europe is that the Asian judges, without the law, without the institutions, and without the paraphernalia that goes with law enforcement, have accomplished so much in the Asian societies in terms of judicial activism that they have interpreted a law that didn't exist, and they have provided remedy to the common, the voiceless, and the marginalized peoples of South Asia. So the difference really is the poverty levels, the affluence levels are different, the education levels are different, the allocation of resources for the sectors that we all here concern human dignity, like sanitation, like right to water, like schooling, like health. Those facilities are not present to the extent they are in Europe. But in spite of those handicaps, in spite of those deficiencies in the Asian way of life, we have found that the judiciary in this part of the world, in Asia, has come up a long way. And that's what I think the European judges and the Europeans need to look at, the imaginativeness of the Asian experience.